You've brought a medical malpractice lawsuit seeking money as a form of compensation for all the harms and losses and damages that you incurred because of a doctor's carelessness. As your case goes through the litigation process, you will be required to give a deposition. What happens if your attorney does not properly prepare you for your deposition? You want to know the answer? Come join me on a walk through the neighborhood as I share with you the answer to that question. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. Okay, so let's step back for a second. You believe that your doctor was careless and caused you harm and injury. You went to the best attorney you could find, and now your attorney hired a medical expert who confirms that in fact you do have a valid and meritorious case. Now your attorney is able to go ahead and start a lawsuit on your behalf. Months after starting your case, you are told that you will have to give a deposition, meaning that you will have to answer questions by the attorneys who represent the various people whom you have sued. This is a pretrial question and answer session that's given under oath. And in pre-COVID times, this would typically be done in your attorney's office, and the court stenographer would be there to record all of the questions you are asked and all of your answers. Your attorney will be there, as well as all the attorneys who are participating and represent the people whom you have sued. In post-COVID times, now, we do the same exact thing, but we typically do it on a Zoom video call. So all the same players are going to be on that call. A court stenographer will be on that call to record all of the questions you are asked and all the answers that you give. And importantly, and many people don't understand this, the answers that you give represent your sworn testimony. So don't think for a second that just because you might be doing this from the comfort of your own home in your living room or sitting at your dining room table, that your answers really don't matter and this is an informal setting. Yes, it's informal, however, your answers represent your sworn testimony and it carries the same exact weight as if you are testifying in court in front of a jury at the time of a trial. So now let's get back to the question that I raised at the beginning of this video. If your attorney does not prepare you properly and sufficiently for this pretrial questioning, what can happen? I'll tell you what can happen. Your entire deposition testimony can go south. Your credibility can be shot. You can destroy your own case. And now you will be unprepared for the questions you are likely to be asked. Now let me share something with you that most people who have never brought a lawsuit before don't really understand. Many people think that when they appear for a deposition, in order to prepare them for that deposition, their attorney tells them what to say. Nothing could be further from the truth. At no time will your attorney tell you what to say in response to a particular question. So you might be thinking, wait a second, then what's the point of preparation? Why does an attorney need to prepare me? Aren't they going to tell me exactly what to say for certain questions that are asked? The answer is no, that's not what happens. The preparation session to prepare you for this question and answer session will typically take place a day or two before you are actually questioned. And there's a key reason for doing that. The reason is that now we want you to be familiar, we want it to be fresh in your mind about the types of questions you are likely to be asked, as well as the substance of what it is you're going to answer. That is often important. Why? Because it's now fresh in your mind. If we were to prepare you a month in advance, 2 months in advance, it is highly likely that you would forget a number of things. So that is why we will do that a day or two before your actual deposition. Your pretrial testimony is so important to your particular case because now anything you say can and literally will be used against you if you later contradict yourself at the time of trial. So let me give you an example. Let's say you are asked what the weather was like at the time of the accident. And you say, oh, it was beautiful, it was sunny, it was 85 degrees out, no humidity, I could see for 20 miles, beautiful day. Okay. Now, a year later, your case goes to trial, and now your attorney asks you something so simple as, hey, Mr. Jones, what was the weather like that day? And you say, oh, it was rainy, it was cold, there was no visibility, I couldn't see anything. So what have you done? What you have done is destroyed your credibility. Why? Because I can guarantee you that the defense attorney will pull out a copy of the transcript of the answer that you gave to that exact question in front of the jury. And he's going to show the jury the two different answers you gave to the same exact question. And now, what happened here? What happened here is that you totally forgot what you had said a year earlier at your deposition, and now, for whatever reason, you give a totally different answer at the time of trial. The defense attorney will turn to the jury in closing remarks and highly suggest to them that you are fabricating your answers, that there is a reason why you have changed your testimony, and the only reason would be to try and help you and your case. So that will destroy your credibility. The purpose of preparing you for your deposition is to get you familiar with the types of questions you are going to be asked. And then you might be saying, okay, how does my attorney know what questions will be asked? Well, this all goes down to experience. If your attorney has been doing this for a number of years, he or she will know exactly what questions you are likely going to be asked. And there are going to be hundreds and hundreds of questions you will be asked. Not just about how the incident happened, but about your background, about your past medical history, as well as what problems and injuries and disabilities and limitations you have going forward, as well as prior to this incident occurring. The goal of a preparation session is not to tell you what to say, but rather to refresh your memory about the events that may have occurred a year earlier, 2, 3, 4 years earlier. And as time goes on, we tend to forget certain details. So the attorney might have information in certain records that he might share with you verbally and say, hey, the record reflects that you were seen on January 5th. Does that refresh your memory? Yes or no? Do you recall what complaints you made to the doctor when you saw him on this particular visit? Do you recall what the doctor told you to do? Do you recall? All trying to refresh your memory and take you through step by step of what you are likely going to be asked. So if an attorney does not ask you and prepare you for the certain types of questions that he should know you are going to be asked, you run the significant problem of not being ready for those types of questions, of now giving contradictory information that will likely come back to hurt you later on, and being surprised by the questions you are going to be asked by the defense lawyers at the time you are questioned. Now, some people turn around and say, wait a second, if I'm in the middle of being questioned and now I'm asked a question to which I really don't remember the answer to, can I ask for a break and then go out and ask my attorney to give me the answer? The answer is no and no. You see, during this question and answer session, you can take a break almost any time you want, except when you have been asked a question before you have answered, which means you can't take a break before giving an answer. So if you are asked a question, hey, Mr. Jones, what was the weather like that day? And now you're trying to remember, and no matter how hard you think you can't remember, and you want to go outside and talk to your attorney, you can talk to your attorney, but you have to give an answer first. And your answer could be, oh, the sky was blue, it was a beautiful day, or it was freezing cold, or you could simply say, I don't recall. I do not recall at this moment. Now, if you go out and take a break, and now have a discussion with your attorney and say, hey, can you tell me what the answer is? Think about what's going to happen if your attorney does in fact give you the answer. You now come back into the room, we go back on the record, and now you say, excuse me, Mr. Attorney, I want to correct something. I now remember exactly what the weather was. It was a gorgeous sunny day. And now he'll say, wait a second, you just told me a minute ago that you didn't remember. Was there something that refreshed your memory about what the weather was like? Oh, well, no, absolutely not. And now here comes the question that the defense attorney will ask. During our break, did you speak to your attorney? Now, your attorney should yell out, objection! Why does he do that? Because he knows what's coming next. The defense lawyer will try to ask, hey, did your attorney tell you what the weather was like that day? Is that what refreshed your memory? Now, that's confidential. Anything you and your attorney say to each other are confidential and private and privileged. And no matter how much the defense lawyer stomps his feet and raises his voice and claims that you have to answer that question, that would be totally inappropriate for you to answer the question. Why? Because conversations with your attorney are, in fact, private and confidential. However, what the defense attorney will then do is try and show that you did, in fact, speak to your attorney and certainly raise the implication that during that conversation, during this break, your attorney actually gave you the answer because there was nothing else to trigger your memory that now you come back and say, oh yes, I remember what the weather was like. So why do I share this great information with you? I share it with you to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and now you're thinking about bringing a lawsuit but haven't done so yet, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.